This Honourable House now resumes its sitting. Call of the roll.
Mrs. Holness, Mr. Bartlett, Mr. Holness, Dr. Clark, Dr. Chang, Ms. Grange, Mr. McKenzie, Mr. Chuck, Dr. Tufton, Mrs. Williams, Mrs. Vaz, Mrs. Malawi Fort, Mr. Charles, Mr. Green, Mr. Morgan, Mr. Warmington, Mr. Main, Mrs. Cuthbert Flynn, Mr. Terry Long, Dr. Dunn, Mr. Hutchinson, Mr. Witter, Miss Smith, Mr. Davis, Mr. Brown, Dr. Brown-Burke, Dr. Charles, Mr. Chin, Mr. Clark, Mr. Cousins, Miss Crawford, Miss Daly, Miss Davis, Mr. Golding, Mr. Graham, Dr. Guy, Miss Hamilton, Miss Hannah, Mr. Henriquez, Mr. Henry, Mr. Hilton, Mr. Jackson, Mr. Lawrence, Miss Lee, Mr. Miller, Mr. Montague, Miss Morrison, Mrs. Nita Garvey, Mr. Paulwell, Mr. Phillips, Dr. Phillips, Mr. Robertson, Mr. Robinson, Mr. Samuda, Mr. Shaw, Mr. Siblist, Mr. Slowly, Mrs. Vaz, Dr. Wheatley, Mr. Williams, Mr. Wilson, Mr. Wright, Mr. Cousins, Mr. Chin,
Members, as usual, it is my great honor and privilege to welcome all of you to the sitting of the House this afternoon. And joining us this afternoon is Miss Izaza, Olga Izaza, who is the UNICEF representative for Jamaica, and Miss Donna Marie, who is also the communications specialist for UNICEF for Jamaica. And I'm particularly happy this afternoon to have two persons here from and both ladies are walking in just now from UNICEF, Miss Olga Izaza and Donna Marie Rowe. We welcome you heartily to the sitting of our Parliament this evening. And it is also my great pleasure to welcome two persons from my own constituency this afternoon, a young lady who hails from Warsaw, and the other person is my right hand in the constituency. Since I have been to South Trelawney, I want to welcome you all to the sitting of the House, and I also want to extend a special welcome to those who are joining us online via the various social media platforms. And of course, PBCJ, who is here with us this afternoon and always here. Members of the House, I welcome you all this afternoon. Members, I want to crave your indulgence this afternoon and seek your undivided attention on a matter that I wish to bring to the attention of this House. Members, there has been some public discourse as to the treatment of reports that have been submitted to this Parliament. And I feel as a Speaker, I must address the matter this afternoon. I want to say, first of all, that the role of the Speaker of the House of Representatives is not ceremonial. And it requires the Speaker to understand and to act in accordance with the Constitution of Jamaica, other laws of the land, and the standing orders of this Parliament. Where the Constitution, the laws of the land, and the standing orders do not provide for specific guidelines on how to treat with any matter before the Parliament, we usually refer to Erskine Nays on parliamentary practice for our guidance. However, members, where the Constitution, the laws of the land, or the standing orders speak to how something should be done, either the Constitution, the laws of the land, or the standing orders speaks definitively to how something ought to be done, practice cannot take precedence over the laws. When in 2017 the Integrity Commission Act was passed, the Act amended the standing orders of this Parliament, and it did so specifically first in relation to Section 68 of the standing orders, and that amendment created an Integrity Oversight Committee. The committee comprises both government members and members of the opposition. The Integrity Act went further and it amended another section, Section 73D. And that standing order clearly sets out how the report of the Integrity Commission should be treated. And as a Speaker of this House, despite the previous practice, for however long the practice has taken place, I feel compelled to abide by the laws and the standing orders. Another point that I want to bring to the attention of the members is that all reports of the Auditor General's Department, all reports of the Auditor General's Department has always been tabled in this House upon receipt of the said report, whether it is a report in the ministry, on an agency, or on a public body. However, members, the practice in general is not, in my understanding, in keeping with Section 30 of the Financial Audit and Administration Act. that section, Section 30, provides for the Auditor General's report on a public body to be tabled where the minister with responsibility for that public body fails to report to this Parliament within a 2-month period. Section 30, subsection B of the FAA Act. And I invite all of you to read it. Members, I want to share with you my own personal experience as a practicing attorney in light of what I have just said. After 40+ years, I went to the magistrate's court some 3 years ago, and I was about to start a trial of a matter. And a young attorney who had just graduated from law school got up, and her objection is that the trial cannot proceed because the summons was not properly served. So, of course, I chuckled very confidently because I'm there for 40 years and I figure she's missed something. So I chuckled because I have been practicing at the bar and doing this time and time again, only to have young counsel get up, open the law, and bring the judge's attention to the specific section in the Act which made my practice as an attorney for 40 years show that I had offended and I had not been acting in accordance with the law. What I am saying, it doesn't matter how long you do something. Practice. If you have done it for years and years and have gotten away with it, it cannot supersede a specific law if there's a law that guides how a matter is to be dealt with. So, the discourse in the social media and letters that I have received only today in this Parliament has caused me to make this statement and to say that as long as I'm here as a speaker, regardless of what we have practiced in this House, whenever it is pointed out to me or I become aware that what I'm doing offends the Constitution, the standing orders, or any law of the land, then I must disregard the practice and abide by the laws that are before me. So, we have to remember that there are committees that have been established by the standing orders, and I have looked carefully through this morning and last night, and there is not one committee where there are specific instructions as given to me under the Act, the Integrity Act, and the amendment as in 73D that tells me clearly what I am to do. So, in view of all that I have said, I must, since it has been brought to my attention, and because I have become aware of it, I must stand corrected as to my previous practice in this Parliament. I have therefore written to the Attorney General, and I have a copy of the letters. I wrote to him 2 letters. One yesterday in relation to the amendments and the Integrity Commission, and I have written to him this morning in relation to the reports of the Auditor General seeking his guidance. I want to say very, very clearly and very, very humbly that I am not the alpha or the omega in relation to any rulings in this Parliament. I am not. But I say very honestly that I must be guided by my own understanding. I'm not ceremonial. I have to read. I have to adjudicate. I have to determine. I have to be guided by my own understanding of the rules and ultimately, as I have done, seek the guidance of the Attorney General of Jamaica, who is a legal advisor to the government on all matters of constitution and laws. So I am making it abundantly clear, because there is much that has been said in the social media, and I have received only this morning a letter that has caused me to seek ultimately the guidance of the Attorney General on both subject matters. And I do believe that it is important, as a Speaker of this House, since I'm not a ceremonial head and I must think and act, that I say these few words and bring it to your attention. Thank you.
Madam Speaker,
yes.
Thank you for your statement. I just have a couple of questions seeking clarity. Could you indicate whether you are in receipt of reports from the Auditor General's Department that have not been tabled, and if you could indicate the reasons for that? That's first. Let me just take your questions. All right, use.
I am in receipt of reports that relate to public bodies, and I have not tabled them in accordance with Section 30, subsection B of the FAA Act, which says reports, and I'm repeating it, Section 30, subsection B says, the Auditor General may, if he thinks fit, or if he is requested by a resolution of Parliament, audit a public body. It then goes on to indicate that the relevant minister who has the responsibility of that body has to be given, and the Act is clear, a time period of 2 months in which to respond. And if the minister does nothing, the Auditor General's report stands tabled in Parliament.
My second question, Parliament has its own legal counsel, and I appreciate that you are trained in that area. Did you seek an opinion from the Parliamentary Legal Counsel in relation to this matter, and what was the opinion of the Parliamentary Legal Counsel? One second. The reason I'm raising that, I understand that you have written to the Attorney General, who is the advisor to the government, but I'm also very strict on the separation of the legislature, which is here, from the executive. So I would like to know whether there was a legal opinion from the Parliament on this matter, because the opinions may not coincide between what the Attorney General says, who is a part of the executive, and the person who advises the legislature, which is independent of the executive. So that's my second question.
Right. And my answer to you is that I have had extensive discussions with the legal officer and the clerk to the Houses of Parliament since I have become aware of this amendment. And having become aware of this amendment, I have had discussions. Ultimately, a decision that is made in here by the Speaker has to be shouldered by the Speaker. So we have discussed it, and there have been discussions as to how the sections are to be done, and ultimately thereafter, the rules say that the Attorney General is the ultimate person, which is what I have done. But I have had extensive discussions since being made aware.
All right, I appreciate the discussions, but was an opinion from the legal counsel proffered on this particular matter?
I have not received a written opinion from the legal counsel.
But, all right. I just want to be clear on. I want to be clear on your interpretation. You're saying if the Auditor General audits a public body, sends a report to the Parliament is going to provide the minister with responsibility for that agency 2 months to respond before it can be tabled? I'm seeking clarity in terms of your interpretation.
In seeking clarity, we have the laws of Jamaica in front of us. I would be obliged if Section 30 be read to the Parliament. It is as clear as ever to me, and if you read it, you will have no doubt. I am very clear, and I know, member, that you can read, so I am open to your reading the section.
That's why I asked about the opinion.
The laws are right here. The laws are sitting in front of us. I can direct the clerk to read the law for clarity, because this is what the Parliament is about.
As a non-legally trained person, I would like, one, I think you did the right thing by seeking the Attorney General's advice, but I would like to see the advice of the Parliamentary Legal Counsel, because Parliament
I am
is
indicating to you that I have had extensive discussions. I do not have an opinion in writing, but we all in here can read and write. I'm inviting you to take the act, and I can read it for you because it is crystal clear to me what it is that the act has said. And because, remember now, I said I very humbly, this job as the Speaker is not ceremonial. And therefore, when I make a decision in here, I have to be properly informed. I must read, I must understand, but I'm not God. And the rules say that if there is a different opinion, as has occurred with the Auditor General, I have a duty to seek the government's legal advisor, who is the Attorney General. And I may, if you wish, because it came to my attention just recently, and I can, if you wish, read my letters that were sent. And I'm still inviting you. And member, I'm confident that if you read this section, believe me, if you read the section to which I refer, I am confident you would not have any doubt as to what I'm saying. Are you?
I would appreciate, Madam Speaker, if you could read the letter that you have sent to the Attorney General. I am asking that because this is, for me, is a very fundamental issue of the independence of the legislature. And you are acting on behalf of the legislature. I have no issue with what you have done in seeking the advice. I would just like to know.
And this is where we debate matters. I request, are you those saying, member, that I would have erred as the Speaker where there's a difference of opinion in referring to the Attorney General?
No, I said the opposite. I said the opposite.
Yes.
I said I have no issue with the fact that you wrote to the Attorney General.
Right.
That's what I said.
And I want to say.
I know, I'm not quarreling with you either.
No. This is where we must debate the matter.
Right.
And I'm going to say two things now. One,
Yes.
I have indicated clearly that there's a difference of opinion. I have indicated that my opinion comes from the FAA Act, which is in front of us, which I've invited you to read, and you have declined to read. I can't understand why is it you would want. I have indicated to you that I have written to the Attorney General seeking his legal advice, as that is my understanding of what I ought to do as a Speaker of the House. And member, I do so very respectfully. I have done so in relation to the both matters that are before this House, because, as I have said in my closing remarks, I am not the Alpha and the Omega of all the rulings of this Parliament.
And Madam Speaker, as I said, I have no issue with you writing to the Attorney General. I'm asking you if you can share with the Parliament the letter that you have written asking for the advice. So we know what the terms of reference of what the AG is being asked to adjudicate on. That's what I'm asking.
And I am saying to you as the Speaker of the House, I have asked the Attorney General to interpret Section 30 of the Financial Audit and Administration Act in relation to the tabling of reports from public bodies.
Madam Speaker, might I? Madam Speaker, I've listened to your explanation to the Parliament and you have advised the members that your decision is based on the FAA. But, Madam Speaker, I am looking at the Constitution of Jamaica, which, to my mind, reigns supreme over any subsidiary law that is passed. And Section 122 of the Constitution says the accounts of the Court of Appeal, the accounts of the Supreme Court, and the accounts of the offices of the clerk to the Senate and the House of Representatives, and the accounts of all departments and offices of the Government of Jamaica, including the offices of the Cabinet, the Judicial Services Commission, the Public Service Commission, and the Police Service Commission, but excluding the Department of the Auditor General, shall at least once in every year be audited and reported on by the Auditor General, who, with his subordinate staff, shall at all times be entitled to have access to all books, records, returns, and reports relating to such account. And two, the Auditor General shall submit his report made under subsection 1 of this section to the Speaker, or, if the office of the Speaker is vacant or the Speaker is at any reason unable to perform the functions of his office, to the Deputy Speaker, who shall cause them to be laid before the House of Representatives. That section goes further, Madam Speaker, at 5. Nothing in this section shall prevent the performance by the Auditor General of such other functions in relation to the accounts of the Government of Jamaica and the accounts of other public authorities and other bodies administering public funds in Jamaica as may be prescribed by or under any law for the time being in force in Jamaica. Now, Madam Speaker, 122. That suggests to me, Madam Speaker, and that's my interpretation, and as a member from Southeast St. Andrew, I will also claim that I am not a legal person. But that suggests to me that any report that comes from the Auditor General ought to be tabled in the House.
Thank you very much for that. And I'm going to invite you, because you've read very brightly and clearly, I am going to invite you now to read the act that governs the duties of the Auditor General, the Financial Audit and Administration Act, Section 30, because let me explain to you, and when you are through, I will explain to you, because Section 29 of that Act embodies what the Constitution has said. And Section 30 goes further to say there is a difference between a ministry that spends funds from the sends money from the consolidated funds, as opposed to a public body which does not spend money from a consolidated fund. It is, may I just explain to you, a public body is a body that earns its own money, has its own board, employs its own staff, and operates the day-to-day running under the direction of a CEO, which is what Section 30, and it puts in bold, if you dare to read it, it says public body. Section 29 confers with what you have read, because in the ministry, I'll give you an example. The Minister of National Security is responsible, say, for the police, the Jamaica Constabulary Force. And the Auditor General has a right to audit. He has an accounting officer in that ministry, and he has day-to-day running of that ministry. And she's obliged to do a report, and when she does that report, she has no need to give him any notice. He has his accounting officer, he's supposed to know what is happening there, and she does her report. 9. And it goes further to Section 30. And right on top of Section 30, written not in the same print, but in bold, public bodies. If you are a public body, say, for example, which one? PICA. You have a board, you earn your money, and the report is done. And I want to indicate to you that Section 29, member, says the Auditor General shall make a report, which indicates she has no choice in the case of a ministry that is spending from the consolidated fund. But Section 30 says, and I'm quoting the section, the Auditor General may, if he thinks it is necessary, in his own opinion, or is directed by a resolution of Parliament. So Section 29 is mandatory and must be done by the Auditor General. The Act is very clear. Section 30 gives the Auditor General the right, if they ever decide to do it, to do it. But having done it, the minister under whose portfolio that agency stands does not have day-to-day running. So having appointed and does not have an accounting officer there. So the minister will in turn now have to have time to go to this agency where he has a CEO and says, there is a report before me that says 1, 2, 3. I need an explanation. And it is very clear to me, or that is my understanding, if not, the legislators would not have set a section 29, and then speak specifically at 30 to a public body. So having read it, I still am inviting you to read publicly Section 30 of the FAA Act. That is my answer to you.
Madam Speaker, could I just ask you what has triggered this change in practice? I mean,
I will tell you. You came in a little
in
late.
the public affairs of the country,
I
tremendously
will.
important.
I will.
The idea of the Auditor General sending a report on a public body to Parliament and Parliament not having sight of it
All
because
right.
the Speaker decides to send it to a
No,
minister.
the Speaker doesn't decide.
Well,
Out
well,
of deference to you,
yeah.
and respect.
I'm asking what has triggered it.
And you came in late, so you didn't hear what I said.
Yeah, that's correct.
And I'm going to repeat, and I know I'm being quoted, so I will read from the text so that you get very clearly what I said. I mentioned that as the Speaker of the House, I have to have an understanding in accordance with the Constitution, the laws, and the Parliament and the standing orders by which I am guided. I mentioned that in 2017, an Integrity Commission Act was passed. You're speaking to the Auditor General now. I'm sorry. In terms of the Auditor General's Act, I gave my example of being an attorney of 40 years and going to court, getting ready to start a matter for trial, and a young attorney had just graduated, got up and made an objection. She said, the matter can't proceed because my procedure was wrong. So I chuckled at her because I figured she's young. She don't understand. So I got up and very boldly said to Judge, you know, Judge, counsel doesn't understand. Whereupon, counsel took up the act and read from the act, which showed clearly that what I had done and had gotten away with for a number of years was not the law. I have given shared that experience to say that in this Parliament, when we do not have a specific law or a guidance as to what we do, we turn for guidance to Erskine May for practice. But where you have a law, a specific law that speaks to how something is to be done, it doesn't matter how long you have carried on the practice. It doesn't matter how many times you have gotten away with it. Practice, in my opinion, in my humble opinion, cannot take precedence over the law. And that is my understanding. But I did say I'm not the alpha and the omega of all the rulings, and therefore, in keeping with the laws of this land, I have referred the matter to the Attorney General for his ruling. But the basic point you asked me, what triggered it? A number of, because two things. One, I have some reports that came to me from the Auditor General's Department. And when I looked at them, they were all public bodies. So in keeping with Section 30 of the FAA Act, they have been logged in at the Parliament's registry, and I'm waiting for the expiry of 2 months. If nothing comes from the minister under whom those public bodies fall, then the reports are immediately tabled in accordance with Section 30 of the Act. The truth is, member, as you have rightly said, this has been the practice of the Parliament for years, but it doesn't make it right, because we have done it over and over and gotten away with it. Doesn't make it right. And in my opinion, I am saying that if there is no law to supersede, I will follow the practice. But I have a law that supersedes. And if I'm not aware of the law, when I became aware of the law, which was some months ago, I wrote to the clerk. And there's no hostility, because when I got in yesterday into this Parliament and saw the letter from the Auditor General, there was no desire on my part to have to write. I immediately asked for her number. And I called her. I said, Auditor General, I note XY. This must be a misunderstanding. I had written to the clerk to tell her according to Section 30B. And she said to me, honestly, she says, I'm so glad you called so we could discuss it. She said, but nothing counts for practice because I've never done it under Section 30. And I said to her, I shared with her on the phone yesterday. I said, no, you have done it under Section 30. But let me tell you, I had a most embarrassing situation where for years I did a certain thing and got away with it, Auditor General. And then one day, an attorney who was years my junior, and I chuckled at her to swallow my tongue, my teeth, and my mouth in the morning. And she brought something, so I said to her, although you have done it that way for years, I cannot know that it has been brought to my attention. Continue. And she said she would write to me. She wrote to me this morning as she promised, because there's nothing acrimonious or hostile. All we are seeking to do is to stand by the laws that guide this Parliament. She did write to me, and she said, in essence, in her letter, the same thing she said, but she had done it under 29, and she expected. And her last sentence in her letter to me, I don't know if I have it here with me, indicated that she was going to, I have it. Her last sentence said, finally, I wish to place on record my communication to you regarding, so she has been courteous to me. She says she wishes to record her communication to me regarding my intent, and this is why I've made this statement, to report through social media the reports which have been submitted to you for tabling. So we had a discussion. She's aware of my opinion. She's aware of, because we spoke yesterday, and I'm aware of hers. And she did say she would write, but she said she would place it on social media. I'm not tech savvy at all, but social media is the way of the world now. So once it goes on social media, and I have not done that, for clarity to this Parliament, and to show that there is no animosity, there is nothing wrong, I am merely conveying, as I feel I have a duty to this Parliament and its members, to say why it is that I am adopting the course that I'm adopting. I am simply saying practice cannot take precedence over law where there is a specific instruction under the law, nothing else.
Can I just ask another follow-up question? Could you indicate how many reports you have received from the Auditor General's Department and when these reports were received by the Parliament? I
really can't tell you how many or when, but I know the matters under discussion now relate to, I can tell you, the matters that have spurred the discussions between us relate to, I think 3 public bodies. For my mind, I think PICA is one. I think the main, forgive me, I don't remember, main road something. If they bring it, I'll tell you. There are three that came up. I really don't remember them, but I can share them with you because they're. But I am, and we both agreed. The Auditor General and myself agreed yesterday that the 3 reports that we spoke to, because that is what we spoke to, were 3 public bodies. But she maintained that she has always tabled them through 29. Listen, I am addressing you. That I am addressing you. You don't need any protection. You can manage. No, but she agreed with me that they were public bodies. But the difference of opinion related to the fact that she said her practice has always been to table them under Section 29. And I've said to her, up to a certain point, I came in and followed the practice. But as soon as I become aware or it is brought to my attention, it is my duty as the Speaker to follow the law. And that's all I'm doing. There is no animosity.
Final question, Madam Speaker. Just so I understand timing, it's about 3 reports in terms of when you receive. Have you submitted those reports to the respective ministers? And have you said
no,
that?
The procedure I do not support. I am not bound, I'm not asked by the law to send it to any minister. What the law asks that I do is that I give a period of 2 months. Hence, the Registrar of the Parliament has been instructed by the Speaker to log every document that comes into the Parliament, the date and time. And I have told the personnel who mans the registry a week before 2 months comes, alert myself or the clerk's office. If I have not heard from the relevant minister, I don't care. It's going on the table of Parliament because that is what I understand the Act to be said.
Madam Speaker, just one.
No,
Section 30 of the Financial Administration and Audit Act, in subsection 2, is dealing with a procedure by which the Auditor General's report on his examination and audit of any accounts audited pursuant to subsection 1 shall be transmitted to the appropriate minister for presentation in the House of Representatives.
That's right.
So this is a procedure by which the Auditor General does an audit, sends it to the relevant minister who has portfolio responsibility for that public body, and that minister then is supposed to table it, but there is a procedure in the proviso there that says the appropriate minister may obtain the observations of the public body concerned on any matter to which its attention has been called by the Auditor General in his report.
You're right.
And those observations shall be presented to the House of Representatives with the report. And if the minister fails within 2 months after receiving the report, fails to present it to the House, the Auditor General shall transmit a copy of the report to the Speaker of the House to be presented by him to the House. So this is a procedure which contemplates an audit being done, a report sent to the minister is given an opportunity to seek input from the portfolio agency which has been audited. If there is any input, that should be submitted with the report, and it's sent to Parliament by the minister. If the minister doesn't act within 2 months, then the Auditor General can send it directly to the House. But what we are talking about here appears to be reports which have been submitted by the Auditor General directly to the Parliament.
No. You are misunderstanding.
Explain.
I'll explain to you. In my conversation with the Auditor General yesterday on the telephone, I said to her, I have received the reports, but they are public bodies. Therefore, I have to wait. And she told me, and I stand corrected. I said, I'm waiting for the minister. She says, her drafts, those are her words, her drafts go to the minister. She specifically indicated that the report that comes to me is something that she has, the only person or her department has knowledge of that final report that comes to Parliament. So my understanding of the law, and you are correct in all its stages, is that listen, you do a draft of something, and you decide that you have looked at it. She's at liberty to change a draft. But once she has completed that draft, she sends it to me. And my understanding of this section is that I have 2 months in which to see. If she has not sent it to the minister, You see, what we are fighting here, to be really honest with the Parliament, and I must say something, members, I'm going to make a very profound comment. Please, don't speak when I'm speaking a little. No, members, hold a minute. No, I really think that what we are fighting in this Parliament this evening and why there's a debate about it, it's because as members of this House, we have not carefully read all the documents that come before us, and we have from year to year continued a practice without questioning or looking at the law. And I'm the first to raise my hand. I have said, listen, I have come to this Parliament as a speaker, and I have fallen prey to the same thing, because I've come and been quite a dodo bird in following certain instructions without asking for the relevant law. But as time goes on, and my interest in the Parliament, and this is the only way the Parliament will grow, is if we read, question, and understand. So what I'm saying to members, when you sit in a committee, Member Cousins, it's so important. When we sit in a committee and the chairman of the committee says, those in favor, leader of the opposition, I'm going to say with all the respect to you, I'm begging you to listen to me, because it's an observation that is a serious thing against us. And the public is now speaking about our obligation, like yourself in relation to salaries. Our first duty as members of this Parliament is when legislation comes to us and it is being passed, don't sit on your phone. Do not have a conversation. Do not have a second Parliament. Listen to the words, because what you agree to is what comes back for us to deal with in this House. And you need to be able to understand. We all fall prey to it, you know, and know that all of us have fallen. And what we're fighting now is that we have practiced a certain procedure that is not in keeping with the law. If it is that there is no law, I will go by practice. But where there is a law, I must be guided. And when there is a difference, the Attorney General is where I turn to. House Leader.
Thank you, Madam Speaker. Madam Speaker, we're quite moved by the fact that there has to be, from time to time, these closer look at the laws and statutes which guide how we act and behave in this Honourable House. And Madam Speaker, as Chair of the Oversight Committee for the IC, I am seized by that. And we are going to be looking at every element of that law which guides how we behave, and we make sure that if we err, we always err on the side of the law. Thank you, Madam Speaker. Madam Speaker, it is intended today to have two statements, one by the Minister of Finance and the other by the Minister of Health. And the other order of business for the day, which will occupy time substantially, Madam Speaker, is to deal with two matters in public business: the Public Procurement Registration and Classification of Suppliers Amendment Regulations 2023 resolution, which will be taken by the Minister of Finance, and the Child Care and Protection Act, which will be taken, I think, an amendment to it by the Minister of Education and Youth. May it please you, Madam Speaker.
Thank you. Minister of Finance.
Madam Speaker, thank you. I rise to just make a statement on the full house benefit to subscribers in the government pensioners administrative services only health scheme. The government of Jamaica, through the Ministry of Finance and the Public Service, operates a comprehensive health insurance scheme that provides a range of healthcare benefits to former government employees, i.e. government pensioners, their spouses and dependent children under 19, and those children who are physically challenged. The health scheme is currently administered by Sagicor Life Jamaica Limited under an administrative service only, i.e. ASO, contract, namely the Government Pensioners Administrative Services Only scheme. The health scheme is contributory and self-insured health scheme funded by the jointly monthly contributions of government, who pay 80% of the monthly subscriptions, and pensioners who pay 20% of the monthly subscriptions. And in addition, the government has some equity contributions to the scheme. The scheme provides coverage specifically for retired central and local government workers, teachers, members of the Jamaica Constabulary Force, the United District Constables, nurses, and retirees of some statutory bodies. As at June 30th, 2023, the number of beneficiaries on the JIPASO scheme, the Government Pensioners Administrative Services Only scheme, was 29,268, with 11,071 individual subscribers, 9,088 family subscribers, and 9,109 dependents. Madam Speaker, the Government of Jamaica cares for pensioners and their families. The current contract was renewed on December 1st, 2021, and expires on November 30th, 2025. The benefits include hospital services such as room and board, hospital outpatient services and intensive care. There are surgical benefits, diagnostic services, and the overseas emergency services as well, which is applicable to the pensioners only. There's a doctor's visit to include home and office visits, specialists and consultation, and of course the full house benefits that covers prescription drugs, optical and dental. Madam Speaker, over the years and based on actuarial assessments, efforts have been made to maintain subscription costs at reasonable rates to ensure that in meeting their 20% portion of the subscriptions, our retirees don't exhaust their pension earnings to meet monthly subscription costs. I'm therefore pleased, Madam Speaker, to announce the improvement in the full house benefit to the pensioners registered on the Government Pensioners Administrative Services Only health scheme. With effect from September 1st, 2023, our JIPASO pensioners will benefit from a 40% increase in the full house benefit for individual subscribers from 20,000 to 28,000, and an increase of 30% for family subscribers from 42,000 to 52,000. Importantly, Madam Speaker, members of the Government Pensioners Administrative Services Only health scheme will have access to these increases in benefits without any increase in their monthly subscription. The norm in these schemes, Madam Speaker, every time the benefits change, is for monthly subscription rates to increase commensurate with the increase in the benefit. However, for this increase, Madam Speaker, in the benefit, there will be no increase, and I repeat, no increase in the subscription rates to our pensioners. Madam Speaker, we are grateful to the service of our public sector retirees, and this scheme, which is a sustainable, self-administered scheme, has a JIPASO monitoring committee with whom we work, and we hope to continue to work with them to improve benefits over time. Thank you, Madam Speaker.
Madam Speaker, I know our pensioners will be happy to hear that news. Could I ask the Minister what will be the cost to the Government of Jamaica for the increase in benefits? And could he indicate whether the figures that have been put here, from 20 to 28 and 42 to 52,000, is that a monthly benefit or an annual? If you could just provide clarity on that.
Thank you for those questions, Madam Speaker. The cost to the government of Jamaica is approximately $200 million, but not a fiscal cost in the sense that the scheme has equity in it. The government ultimately holds the liability in the event the equity can't service the costs on that occur in any year. The financing of this increase in benefits comes from use of that equity and does not require an additional fiscal contribution from the government of Jamaica. But the cost is $200 million. The amounts and the full house benefit is just one of a range. You have hospitalization benefits and there's even an overseas medical benefit and a whole page of benefits. This is the full house benefit, which is like a catch-all for the things that are not specifically covered, and as it says, it's for prescription drugs and so forth. These are annual amounts that we have increased by 40% for individuals, for the individual benefit, and 30% for the government benefit, for the family benefit.
Minister, thank you. How much equity is in the scheme, and how long do you anticipate that equity will finance this increase before you either have to increase the subscription or pay for it out of the budget?
Thank you for that question. If I were to go from recollection, which can be dangerous sometimes, but I believe the equity is in the region of just over $1 billion, about $1.4 billion. The scheme is sustainable and has been sustainable. There was a time in the past that the government of Jamaica would have to fork out subventions to the scheme on an annual basis. I will say that for the last several years, that has not been the case. The thing about it that's quite admirable is that the scheme is, jointly administered. If I'm using that word, it's administered by the health insurer provider, in this case Sagicor, and it's bid every couple of years. But in terms of the policies and so forth, there's a monitoring committee made up of government pensioners who meet on a regular basis to look at the performance of the scheme and who make recommendations that the government considers and approves if actual assessments recommend them. And this is one such example of the government taking on recommendations of the pensioners monitoring committee. But given the equity that's in the scheme of about $1.4 billion, $200 million keeps the scheme sustainable. And with the evidence of the past several years in terms of claims versus contributions, there's everything to suggest that this scheme is self-financing from here on, unless, of course, we change benefits again in the future. And we do this with actuarial advice, I should add, that we submit the recommendations to an actuary, the actuary looks at it, costs it, and then they come back. And, just happy that we've been able to increase the benefits in this way at this time. Yeah.
Just out of interest, that equity, which I assume is the surplus from the inflows versus payouts over time, where is that held, that equity? Where is it kept? Is it invested, or what happens to it?
Right. So that equity is from government contributions. So most of it would have come from the government putting funds up over time. And yes, any excess of subscriptions over health costs, less administrative fees, also adds to that equity. When you say where is it kept, the scheme is administered by. Yes, it's a separate fund of resources, correct, and it's administered by for this period by Sagicor.
Since it's funded by an 80-20 contribution ratio between the employer and the pensioner, or the government and the pensioner, is it not reasonable to say that the pensioners, that body of pensioners, would have contributed to 20% of that equity as well? Well, I mean, you said it was the government that's funded the equity, but I don't quite understand how those two...
I say that because of the history of the scheme. The scheme was not... is much better run today, meaning over the last few years, than some period in the past. In the sense that in the past, the government would have had to, above and beyond its 80%, would have had to, because the government retains the ultimate liability. If the 80-20 can't meet, the government has to make it up. And in the past, the government of Jamaica has had to step in several times, over several years, to top up. And in that case, I'm saying that the contribution of the government over time has been much more than 80%. And the equity is... Yeah.
Minister, are you asking for the motion to be approved? No. Oh, statement. I'm sorry.
Thank you very much, Madam Speaker. Madam Speaker, I take this opportunity to again call the attention of this Honourable House to Jamaica's growing problem of non-communicable diseases or lifestyle-related diseases, NCDs for short, and the requirement, which I've spoken of several times, for a whole-of-government and whole-of-society approach as a response to encouraging health-seeking behavior. We have what I describe, Madam Speaker, as a sick population, and the evidence bears that out. 1 in 3 Jamaicans suffer from hypertension or high blood pressure. 1 in 8 diabetes, parochially called sugar. 1 in 2 overweight or obese, which is a modifiable risk factor. Modifiable meaning with adjustment in lifestyle, we can change that as part of the NCD's profile of our population. Together with tobacco use, physical inactivity, harmful use of alcohol, and unhealthy diets. If we were to adjust these, then the health profile of each of us and collectively as a population could be adjusted in a positive way. Further, Madam Speaker, colleagues, 4 of every 10 people living with these diseases are unaware of their status. And again, I spent some time in my sectoral addressing that. And it is in that statistic that I'd like to make a particular announcement today. So it is a fact, the numbers bear it out, that Jamaicans are in fact dying younger. And it didn't start over the last few years. Based on the trend analysis over the last decade, the evidence is showing that persons based on average life expectancy, about 75 years, are in fact getting ill earlier in their life stage, and many are dying before the age of 75. In fact, the in-depth analysis suggests that in 2020, 59%, or some 12,747 people had died early, meaning before their 75th birthday, based on the average life expectancy in Jamaica. And NCDs, or lifestyle diseases, are a significant driver of those numbers. NCD deaths, Madam Speaker, in 2020 were the cause of some 144,853 potential years of life lost. If you were to calculate death prior to 75, then an accumulated number of life years lost would be over 144,000. A 30% increase in potential years of life lost, more than over a decade ago, over 10 years ago, which shows a progressively worsening situation. Madam Speaker, as I had explained in my sectoral presentation in May, this rate of increase for persons who are getting sick earlier, dying younger as a result of lifestyle disease, is increasing, 30% increase compared to 19% for all causes. And the data is telling us that more Jamaicans die from sudden and unexpected emergencies like heart attacks and strokes, or lose their limb because they have diabetes and don't realize it until they have to lose a limb, and are unaware of their health status, so they cannot do anything about it because of ignorance, lack of knowledge. Madam Speaker, the reality is such that the ministry, again captured in the sectorial, had to deliberate and in a way to champion behavioral change. We do so through public education, making persons aware, raising awareness around the critical issues, and influence, hopefully, the decision-making process towards pursuing healthier lifestyle. The issue around screening, Madam Speaker, is central to that, health screening. And we therefore launched in the sectorial in early May an intervention called Know Your Numbers, which not only encourages Jamaicans to get in the know about their health status, but also seeks to ensure that they are provided with an opportunity to get health screening. So it's about encouraging, but also providing the facilities in a convenient way for them to actually get screened. It is through this intervention, Madam Speaker, that I announced today an initiative over the next few months as part of this overall Know Your Numbers campaign, with the members of parliament being the primary drivers. And we wanted to start with members of parliament, Madam Speaker, because we believe in public health and as a government that this is where the leadership must start. We need to know our own numbers, but we need to help those who we lead to know their numbers. Otherwise, the responsibility of not knowing still resides with us, and we have to provide that leadership. So from that perspective, Madam Speaker, the summer program that I'm about to announce will include $1 million Jamaican allocation to each member of parliament to host at least 2 health fairs. One could be a back-to-school health fair, but another, the other we would want to see addressing the older post-high school population. So that will be one initiative, Madam Speaker, 2 health fairs over the next 2 to 3 months. Once persons who have been tested, and you're doing so in conjunction or collaboration with the regional health authorities and the National Health Fund. Once persons are encouraged by the leadership on the ground of our members of parliament and their respective teams, then we will take additional necessary steps to provide counseling and support to these persons. If they are in good stead, encouragement to remain that way. And if they are not, Madam Speaker, to provide support through the health system, starting with the health centers in the community, but if necessary, elevate to the secondary health system, the hospital care, to allow persons the opportunity to correct any challenges that they face. Central to this, Madam Speaker, which is the second component of the announcement, is the need to restore credibility to our community health centers. Madam Speaker, we have 325 community health centers, or clinics as some people call them, throughout the country. And the idea of primary health care is to have a health center within 10 miles of the residents of each member of the population. And it has had to adjust with population shifts over time. But key to that primary health care model, which I again spoke to in the sectorial, is to provide community-based intervention to our population so that persons have access to a doctor, a nurse, basic equipment, screening being absolutely central for that. Now, over time, one of the challenges, and we observe that every day because we see the overcrowding in our hospitals, is that persons bypass our health centers to go to the hospital because they perceive, rightfully or wrongfully so, that they will get more attention in the hospital. And they will drive past the health center to go to the hospital. The result of that, Madam Speaker, is overcrowding. And I know that complaints are out there around overcrowding, and we're trying our best. But the fact is, if the rate of increase of sickness continues, we can't build enough hospitals to address that issue. So the prevention side is key. So we wanted to send a message as part of a process. This is not going to do it fully, but it starts by allocating, as part of this summer program, an additional $2 million Jamaican dollars to each member of parliament. And the program around Know Your Numbers and primary health care, which are very much linked, is to work with the regional health authorities, the parish health officers in particular, within your parish as an MP, to identify, based on a needs assessment, that particular primary health care facility that is most in need of very, very basic support. As part of the credibility restoration, mobilize the community within and around that particular facility to be part of that enhancement using those resources, and to allocate a portion, I'm suggesting maybe $500,000 of the $2 million, to doing a third Know Your Numbers activity around that particular health center during that period of 3 months. So essentially, Madam Speaker, the $2 million is to enhance, to the extent that you can, working with the regional authority, a particular health center, and those people living in the immediate vicinity, to again bring them out and give them an opportunity on a particular day to come and to get screened under the Know Your Numbers program. Once they are screened again, the same system applies. Depending on their condition, we will either elevate the investigation further through the health center, if they have to do additional tests, or if they have to go to a hospital, we will recommend and follow on to give them that particular support. Madam Speaker, we're at the starting gates in terms of what we have announced, and we're starting here because this is where I believe leadership is critical. The idea is to have, therefore, approximately 3 health fairs organized with the leadership of members of parliament, supported by the regions and parish health. And if we average 80 to 100 persons per health fair and 3 per constituency, you're looking at anywhere between 15,000 and almost 19,000 persons over the next couple of months who would be screened, including a segment of our young people in our schools. Now, data is critical to this program. And so the National Health Fund, who is providing the resources, will work with the regions, and they have already put in place a system of data collection. In other words, if you do 100 persons, and 20 of them have hypertension, and 10 of that 20 are so bad that they are bordering a stroke, they'll be referred to the hospital. But we're going to collect that 100 persons data, and we are going to use that data to determine what are some of the things that are necessary in terms of the profile of the population. So it's not just an immediate response. It's not just building back credibility at the community level. It's about the people in the community and what we do for them once we determine what their particular condition is.
The Minister's time for speaking has expired.
Madam Speaker, I beg to move that the member's time be extended sufficiently for him to complete his presentation.
Members, the question before the House is that the Minister be given sufficient time to complete his presentation. Those in favour? Those against? The ayes have it.
Thank you, Madam Speaker. I'm on the final lap. Just to remind members, Madam Speaker, that the 4 critical tests that we will do would be blood pressure, blood sugar, body mass index, and cholesterol. Those will be enough to give us a good indication as to the health status of the individuals, and then trigger a likely follow-on if that becomes necessary. I want to also quickly say that I'm using the opportunity to encourage MPs, but also other stakeholder groups within the society. We are going to be engaging the faith-based organizations, the community-based organizations as part of their own influence and leadership. But we are encouraging others who may want to contribute, companies around their staff, this screening process of Know Your Numbers, to come and contact us, give us support. We will work with the health system, the doctors, the nurses, to make sure that the program is expanded, because we believe it is absolutely critical, Madam Speaker. Madam Speaker, we did a slight trial run recently in Clarendon and St. Mary. 400 individuals benefited from these two activations. We did some 320 in Clarendon, 400 in St. Catherine. We did 600 blood pressure tests and body mass index, 80 dental exams, 85 HIV tests, 38 eye exams, and I could go on. So we have started this program. It's going to be expanded. You'll hear more about it, and to the extent that MPs are on board as part of all of society approach, I think will augur well for us to help Jamaicans to know their numbers, know their health status, and hopefully avoid unexpected crises with their health. Thank you very much, Madam Speaker.
Thank you very much, Madam Speaker. Minister, I want to again say you have given an update on NCDs as you did in your sectoral presentation. You indicated that 1 in every 2 is overweight or obese, and I looked around the house, you know. Yes, we always have to look here first. But the truth is that that's the reality of where we are now in this country. And I will agree with you that it needs reiteration in our people to the fact that we are living on the edge in terms of not only our personal health, but by extension the fact that it is a cost to the country to try and treat some of these NCDs. I want to thank you for the fact that you have indicated that there is going to be something in your sectoral and you are presenting it here today. There are a few questions that arise, however. One, the $1,500,000 per health fair. Will the resource persons who will be, health fair, there are 2 at 500 each, right? Will the resource persons, such as the doctors and all of those other persons who are going, will that money come from that $500,000? Or will it be earmarked to provide transportation, food, refreshment, and stuff for those persons who are coming to the fair? Secondly, you indicated that the regional health authorities will be integral, as well as the National Health Fund, in this program. So you suggested, but can you reiterate that they will be the ones who will do it, and that the members of parliament need not retain the services of doctors outside to come in and do those? The third one is, you mentioned that the third health fair, you elaborated on it, which is out of that $2 million. Right, 1.5 to fix the health center, and you're hoping that members of parliament will have a third health fair costing 500 out of that. So basically that amount has been whittled down for improvement to about 1.5 as opposed to 2. You know, is there any way that that cost for the additional health fair could be borne by the Ministry of Health / National Health Fund, so that the well-needed $2 million for those health centers that are going to require that amount of money is earmarked directly for repair of the infrastructure? The other matter, Minister, is you mentioned the 4 checks that will be done: hypertension, blood pressure, blood sugar, cholesterol, BMI. Will there be persons there who will do, even though you might not have the full gamut of examination, be there to do PSAs for men over the age of 40? Because that is critical as part of the screening too. And if that was not contemplated, could I suggest to you that as part of the NHF and the Regional Health Authorities intervention, that be considered as part of the gamut of tests, increasing from 4 to 5. And finally, you said that the Regional Health Authorities will be, as it relates to the infrastructural repair, be coordinating that. What was the Member of Parliament supposed to do? Just identify the clinic that they would want to have repaired and then send it on to the respective regional health authority, the director, and then they will take it from there.
Thank you, Madam Speaker and the member. I have about 6 here. Let me just do these and then. The idea, and each member of parliament will get a letter outlining, or should be getting one as we speak. The idea is, and that may bring some clarity to the approach. Okay, the idea is not to pay the doctors, the medical staff. The regions will provide them. So a scheduling will have to take place, which is why it's important for them to be in touch, and they will be in touch. We have set that up already, so you'll get a call over the next few days. The primary role of the MP would be to provide leadership around mobilization in the first instance, because let's face it, you know the people, we know the people, and as a matter of fact, we're probably bearing some of the cost of healthcare and otherwise of many of these persons. So it's really about using our network that we have. I believe outside of faith-based organizations and maybe sports, members of parliament have the greatest capacity to mobilize people. That's what we do. That's part of our job. So it's justified to engage and to get you to do that. So that would be the primary role. There may be some incremental or auxiliary cost around the setup, which the regions will communicate with you on, but mobilization is key, maybe refreshments, that sort of thing. The idea around the possibility of paying additional doctors. The reality is, while we will provide a certain amount, I gave an average number, 80 to 100 persons. Let's say you have a case where you might have 200 or 300, because there are some communities that will provide that. That's something you work out with the regions, but I would not shy away from saying that you access some of your CDF to support some of that activity. This time of year, for example, my CDF, I have an allocation for health back-to-school clinics. So to the extent that we can complement what we are getting, I think we should, one. Secondly, I did also speak to the need to mobilize community-based groups, the church, the private sector groups in our area, and explain and provide that leadership about why this is important from all aspects. And so I'm hoping that creativity around the leadership will take place. So this is seed money, not necessarily money to lock you narrowly into, I will only do what this can provide. Hopefully it will encourage other forms of activities. The issues of the PSA, we did PSA actually in Maypen, because we had the capacity to do that. And I suspect some of those places will do more than what the 4 that I've said. But based on the clinical advice that I have been given during the development of the program, which you probably will know more than I, these 4 measures could provide sufficient technical information to trigger a recommendation for other things. And I'm sure you would be very aware of that. So that would be the approach, Madam Speaker. Thank you.
Thank you, Madam Speaker. Minister, first of all, I commend the project, and you and I have been working closely together. Yes, and I want to thank you for the upgraded health center in Moneague, which we opened, so I am appreciative of that. So Southeast Centre, Madam Speaker, has 2 very good health centers. We have a center of excellence in Claremont, and we have a very upgraded center in Moneague. The 3 questions I want to ask surround food, school and the health centers. So, Minister, in my case, the 2 million, while I am grateful for it, I'm not sure how far that could go. Because one, if I'm wondering if that 2 million could be used to help my constituency in upgrading nurses' stations at schools. In other words, students need access to better nursing facilities and healthcare facilities within schools, and I'm certain of one or two that I would prefer to use that money on across the constituency, since we have recently upgraded some of our health centers. So I'm asking the Minister if that is. For the health fair, $1 million is grateful, but it's not going to really dent and bring forth what it is that the ministry needs. I'm therefore asking if the ministry can give me a mapping of the healthcare needs in my constituency. In other words, I'm sure you know where cases of diabetes are, cholesterol, etc. But I want to go a step further, because I'm prepared to match some of my CDF funds. But I would prefer if I could sit with Tamika and some of your other personnel at the ministry and develop a community aid intervention. In other words, I would prefer, when I get that mapping, to use that $1 million or more, rather than have a health fair, to spend at least 2 months across the constituency going to the areas, to the people. Because to get them to come out, there was a time when community health centers, apart from psychiatric care and mental health, they went into the constituencies to test blood pressure, all of these other things. So I would prefer to go back to that, especially for some of the older people. And to also bring the requisite medication, Minister. Because it doesn't make sense you check for high blood pressure and the people have high blood pressure and you can't give them some medication on top of it. The second question I have for you, we speak about obesity, and the figures are in here. Nobody in here is obese, and nobody in here, I think, suffers from overweight issues. No, I don't think so. And everybody in here has some degree of movement. But there's a real issue, and it doesn't make sense. Your ministry continues to have know your numbers. The Ministry of Finance doesn't work to put policies in place for people to afford protein. So what typically happens, Madam Speaker, is a lot of Jamaican families fill up their children on starch, rice, flour, because they can't afford the chicken, the meat, because of the costs. I'd like the Minister of Finance to hear what I'm saying. A lot of the products that they're also eating, the offals, like the chicken neck and back, the liver, some of the kidney, the small tins of mackerel are all imported, and they're still not getting enough protein. I want to ask you, because in terms of doing this and in terms of knowing our numbers, can you please seek from the Ministry of Finance and work with them to have a policy where we reduce the cost of chicken and other forms of proper protein so that young people and families can have nutritious meals, and perhaps to find out how we can have a basket of goods that the duties are removed that they can afford. So in terms of what you're saying here and knowing your numbers, it has to go all the way across, Minister. And so I'm asking you if that is also in place. And the final thing, Minister, is, are you doing anything, if we go back to the health fairs, will there be anything done for children? You're doing cholesterol and body weight and all of these different things, but it's back to school. And so a lot of the parents who will be requiring medicals to be done, is there something that can be facilitated, or will they have to go to their health centers to get that done? Thank you.
Thank you very much, Madam.
Before you answer, there's one question that I'd asked that you did not reply to, which is the potential for beefing up that 2 million. The potential for beefing up the 2 million to accommodate another health fair.
Madam Speaker, let me begin by thanking the member for recognizing the improvements in her constituency of the 2 health centers. In fact, this government has actually improved 100 community-based health centers over the last 3 years. 100 of the 320. So we are doing a lot to try to make that happen. And I appreciate the recognition. And I'm sure the staff and those who use it are happy out. Now, on the issue of the education and the diversion of the resources to health centers, we work closely together. The minister, my colleague, to my right. And one of the things that we have to be careful of, and it's not a criticism, but I know there is always that tendency to find all the solutions in one initiative. This is not a panacea, and it's not expected to solve all the problems of your health status or in the country. It is one initiative of several initiatives, and I can list a whole range of them. So take schools, for example, and nutrition, which you referenced when you made mention of the Minister of Finance. We have a school nutrition policy. No, hold on, let me just finish. We have a school nutrition policy that is now in its final stage to become a white paper from a green paper, having gone through a range of consultation, the Ministry of Education, myself, or the Ministry of Health. That policy, once it gets here, I'm hoping members will support. And then the Minister of Finance is going to come in, because it's going to have implications for the menu that is that is served to our students or children in schools, which will address some of the balanced diet that you're referencing. Well, let me just say that the consultation did involve parents. Minister, you and I did a lot of that. So the point is that within the schools, the Ministry of Health does touch down on a number of initiatives. We have a mental health program going on now. We have trained members of staff around psychosocial support. And then, of course, you have the nutrition policy. But these resources, to be more direct to your question, were not envisioned to go into schools, because there are other programs addressing schools. But I take the point that we need to continue our efforts within the schools. In terms of the mapping, that's a good point. I think that we need to touch down where the need is greatest. There are some other initiatives that are going to be aligned to know your numbers. One involves mobile health clinics. So we'll be unveiling a series of mobile health clinics, clinics on wheels, and they are going to go into underserved areas, furthest from health centers, and will work with MPs, councillors, civic groups, community groups to do exactly what you're saying. But I would prefer you keep it there. But no, let me finish. I think you can have a conversation with your parish health officer that you referenced. And if there's a way to be more creative around serving those who we need to, because remember I started by saying 4 out of every 10 don't know their numbers. They don't know they're sick. And therefore, they are the ones that we need to target, which is why I say it's a good point. So have a conversation with your people so you know exactly which communities to go in, and then how to locate the particular health clinic. We did say one of the 3 health clinics should be back to school. So we're also including that into the system. And I think that's it, Madam Speaker. The question from my colleague who asked before around more resources for top-up. I did say CDF is an option, given that we're all committed to some CDF for health, but also the civic groups within the communities. This is seed money to try and get the program started. Thank you.
Minister, I thought you left out one thing, the upgraded one in South Trelawney. I didn't hear it. No.
Madam Speaker, we will speak about that outside of this forum.
Announcements.
Laid on the table of the House today are the following: Annual Report on Audited Financial Statement of the Jamaica Civil Aviation Authority for the financial year 2021-2022. Annual Report of the St. Anne Development Company, which is under the Urban Development Corporation, for the financial year 2013-2014. Annual Report of the National Hotels and Properties Limited for the financial years 2012-2013, 2013-2014, 2014-2015, and 2015-2016. The Auditor General's Department Certified Appropriation Accounts, Head 15,010 for the Jamaica Information Service for the year 2017-2018, Head 26,024 for the Department of Correctional Services for the year 2017-2018, and Head 4220 for the Registrar General's Department for the year 2013-2014.
Bills brought from the Senate, petitions, papers, reports from committees, notices of motions given orally, questions and answers to questions, motions that may be made at the commencement of public business requiring notice, motions relating to sittings of the House, motions for leave to introduce bills, presentation of bills without leave of the House first obtained, public business.
Madam Speaker, as indicated earlier, the matter for public business will be two items. One, the Child Care and Protection Act, which will be piloted by the Minister of Education and Youth, Honorable Favour Williams, and the Public Procurement Registration and Classification of Suppliers Amendment Regulation 2023 Resolution, which will be taken by the Minister of Finance and the Public Service, the Honorable Nigel Clark. May it please you, Madam Speaker.
Minister of Education.
Thank you, Madam Speaker. Madam Speaker, I wish to commence the debate on the bill entitled An Act to Further Amend the Child Care and Protection Act 2023. Madam Speaker, the National Children's Registry receives approximately 5,000 cases per year of children displaying behavioral challenges. The age range of children, or both male and female, often deemed to have behavioral problems, is between 14 to 17 years old. These cases are treated through the Child Protection and Family Services Agency's Children and Family Support Unit, CFSU. Most children who are treated by the CFSU are able to remain with their families during the course of the necessary intervention. However, for those with severe problems, there is a need for residential treatment, which, in the absence of a suitable alternative facility, invariably causes these children to be placed under a correctional order. Madam Speaker, on December 6, 2016, a joint select committee of Parliament was appointed to complete the statutory review of the Sexual Offences Act, together with the review of other legislation aimed at, inter alia, the protection of women, children, the disabled, and the elderly from violence and abuse, being the Sexual Offences Act, the Offences Against the Person Act, the Domestic Violence Act, and the Child Care and Protection Act. The report of the Joint Select Committee was adopted by the House of Representatives on November 5, 2019, and by the Senate on July 10, 2020. Madam Speaker, following the Joint Select Committee's report, there was renewed advocacy for the removal of the power of the court to make a correctional order on the Section 24 of the CCPA and connected matters by child rights organizations, including Jamaicans for Justice and the United Nations Children's Fund, UNICEF, in Jamaica. Madam Speaker, in recognition of the fact that juvenile correctional centers do not have adequate resources to treat and rehabilitate children who are referred to these facilities by order of the court under Section 24 of the Child Care and Protection Act, and after taking into consideration the underlying concerns expressed by the Joint Select Committee in its report, the Ministry proposes to strengthen the Child Care and Protection Act to provide a wider range of options to the CPFSA in dealing with children in need of supervision or behavior modification. Madam Speaker, the position of the Ministry of Education and Youth is that allowing the use of a correctional order without a child committing a criminal action under Section 24 of the Child Care and Protection Act is an injustice against a child who may be exhibiting trauma derived from abuse, neglect, and suffering, and needs psychological treatment. The Child Protection and Family Services Agency has seen numerous children in this category and has therefore advanced the proposal to treat this category of children by placing them in a facility to treat with their individual psychological needs. The amendment of the Child Care and Protection Act includes the repeal of Section 24(2), which will enable Jamaica to become compliant with its obligations under notable international treaties on child justice and child rights, and establish a fairer and more equitable means of treating with cases involving children exhibiting behavioral challenges, thereby promoting the best interests of the child. Madam Speaker, the amendment of this legislation that resides with the Ministry of Education and Youth is part of the bigger transformation of education. A major pillar is the governance, accountability, and legislative changes. There are many such amendments to be done at the ministry, including the broader Child Care and Protection Act, Education Act and Regulation, Jamaica Teaching Council Bill, higher education, and so on. Madam Speaker, it is with all of this in mind that I commit this bill, which seeks to further amend the Child Care and Protection Act, to the House for approval. The amendments will repeal Section 24 of the Child Care Protection Act, which makes provisions which may include a correctional order regarding the treatment of a child brought before a court by a parent or guardian who claims to be unable to control the child. B, provide instead for any child alleged to have behavioral challenges to be brought before a children's court as being in need of care and protection. C, make provision for the orders that may be made by the court in respect of such a child to include a residential therapeutic order or a non-residential therapeutic order having regards to the results of a social inquiry report and a psychological or psychiatric report in respect of the child ordered by the court, and D, provide that a children's court before which any child is brought under Part 1 of the Act, other than a child alleged to have committed an offense, may order that the child be placed under the care of a children's officer for a specified period not exceeding 3 years instead of a probation and aftercare officer as currently obtains under the Act. Madam Speaker, I look forward to the members' support of this very important piece of legislation. Thank you, Madam Speaker.
Madam Speaker, I'm going to ask whether we could suspend this debate. The bill is taking an approach which I think requires some additional thought before we speak to it. The issue, which has been a long-standing problem, is the ability or the jurisdiction of the court to grant correctional orders for children who are exhibiting uncontrollable behavior. And these are not children who've committed a criminal offense. And it has for a long time been considered a dangerous anomaly, which ought not to be part of our law. We've been criticized for it in various international bodies, UN bodies, and so on. And the question was, how do you deal with that? The solution appears to use the children's court as a kind of triage for a whole new body of cohort of children, which is children exhibiting behavioral challenges. And this includes things like acting out, truancy, bullying, staying out late at night, smoking cigarettes. I mean, many of us may have done these things as teenagers. So I'm just saying that for me, to bring those into the children's court as a triage center for making these kind of orders is very unusual. And I know as a fact that UNICEF has problems with it. And I think, I've seen a letter written to parliamentarians today, I think, by Jamaicans for Justice. So I ask that we could, if the minister would permit us to suspend the debate now and give us some time to really look at this, because the approach is, I think, problematic. And I'm not comfortable with attempting to speak to it, having only really focused on it today.
Thank you, and I thank the Minister for yielding. Madam Speaker, all of us, because when it started, and I remember clearly, what happens, as you know, in the court system is when a mother or a guardian cannot control the behavior of the child for which they have responsibility, they would carry them to a police station and have them remanded. And that came with a number of significant adverse effects of that child, because sometimes that child would be remanded for 48 hours and then they would end up in a place of safety or a remand center, which is not in the Ministry of Youth, not in the Ministry of Education and Youth, but would be in the Ministry of National Security. And over time, we were breaching a lot of the conventions that we had signed. So police stations were built for children, etc. Fast forward to where we are now. What was intended for the removal of an offense that was called children with uncontrollable behavior, because when that child now ended up in front of the court, the judge would ask the mother, the guardian, the grandmother, who gives permission for this child to be remanded, and are you okay for the child to be remanded for uncontrollable behavior? That guardian or parent would have to say yes. And many times that child would now get lost in the system for years because the parent wouldn't want to come back for the child even when the child became an adult. No. what are we trying to do as legislators? And we came here some time ago when Daniel was heinously murdered, and we do it time and time again. We have a problem in this country with certain behavioral issues. We know that. But the issue to fix behavioral problems is to not make it a court situation, to now put the child back in a situation. Many of our children need therapeutic care, and I am happy that one of the projects that was announced in here by me at the time as the Minister of Youth and Culture, which was a child care therapeutic facility, which was recently opened, has now been opened. And so that's a step in the right direction. Yes. No, that is not something to clap about. No, I'm telling you why. It's not something to gloat over. And I tell you why it's not to gloat over, Madam Speaker. Sometimes we come here and we beat the desk gloating about things, and there's a transitional process. The children that are going to go here have real issues. Some of them will want to escape. Some of them have real emotional problems. I agree that we need to take some time, Minister. This is not an acrimonious situation, but we need to take some time. And what? No, it's not. The bill has not been here. All I'm saying, Madam Speaker, the Minister has started the debate. It has started. It will continue. I know the leader of government business wants to go on break. So yes, we are starting the debate. All we're saying, Minister, you can fast track this and ram it through, right? And you will be subjecting a lot of children to going. Madam Speaker, we can ram it through, but like the Road Traffic Act, hang on a second, like the Road Traffic Act, let us caution ourselves to ensure that, like what you said earlier, that we err on the side of the law to make the law important. Because you said that at the end of the day, we rubber stamp these things. So we have to make sure that whatever we're stamping meets the approval of what we believe. And there are two clauses in here I personally I don't agree with. That's all I'm saying.
This is a... Madam Speaker,
just a moment. Just before the member. Members, I want to remind us all that this is a place that we debate and we take our time because, so that exactly what I said earlier today, we go slowly and make sure that what it is we are putting into law is indeed what it is we want to do. It's an opinion, and that is it. Member, your turn.
I think one of the good things about this amendment is that there is commonality within the House, that children who have not been charged with a crime should not end up in a penal institution. There are colleagues on both sides who have advocated for this. There are multilateral organizations such as UNICEF, agencies such as the Office of the Children's Advocate who have advocated for years, over a decade, for this. The government decided last year to pull out Section 24 out of the general amendments to the Child Care and Protection Act. Why did we do it? While I was minister, while Minister Hanna was a minister, while Minister Green was a minister, while Minister Terry Long was a minister, despite child diversion and various other initiatives by the government, both sides, we found that there were certain courts in Jamaica who insisted on sending children to penal institutions. It was not a general behavior across the judicial system, but we are still having courts. And I say to the House, there is a desire for delay. If one child during this delay is sent to a penal institution, it's a wicked and cruel act by the country and this government. This matter has been operating from before I was State Minister along with Minister Williams. The AG's department has opined on it on numerous occasions. LRD has opined on it on numerous occasions. The Ministry of Justice, the Chief Parliamentary Council. There was robust debate within the judicial ecosystem of the country about just merely even the definition of words to make sure that we got it right. While I appreciate the concern of my friend over there about delay, based on everything that has taken place over the last several years, no more children should be locked up in penal institutions. I'm very happy, Minister, that we finally completed the therapeutic center and also the other one in St. Anne that has also been completed under this administration. I'm happy that you have also done the audits of the children's homes and that we have given more resources in terms of better pay to social workers to work with CPFSA to go into communities. The approach I recognize by this government, Madam Speaker, is not just about Section 24. Going through the process, we still have the Adoption Act that is being dealt with now, the general amendments to CCPA, which was waiting on this to be done. We also have the Children's Guardianship Act that is also going through the process. So I don't want the public to assume that we're just dealing with, quote-unquote, uncontrollable children. But I will support the Minister in her decision if we go forward, because I personally am very disturbed that even now there are children who are deemed uncontrollable in penal institutions being exposed to charged criminals, people charged with murder, rape, sexual assault, larceny. A child who may be disrespectful, a child who may have run away from home is right now as we speak in a prison with, of course, we know that the CPFSA and the Children's Advocate are ready and waiting to go to court as soon as this law is finished to remove these children. The facilities are ready, both the one that is at Maxfield that is more of an outpatient and the one that is in, Minister, if you could remind me the name of the one in St. Anne. Windsor, which is a secure facility, newly renovated with good surveillance, ready to take these children out of the prisons that they do not deserve to be. So, Minister, you have our support based on your decision. Thank you, Madam Speaker.
Madam Speaker, I also stand in support of repealing Section 24, subsection 2B of the Child Care and Protection Act. Pardon? Madam Speaker, again, as I said, I have seen firsthand some of the children who are deemed uncontrollable in our penal system, and I don't think they belong there. Madam Speaker, repealing this section of the Act isn't just a signal that the government is serious about protecting our child, but we do understand that there are varying factors, as you mentioned, as to why our children act out. And really, that's what it is, acting out. Madam Speaker, it was reported in 2020 to 2022 that there were more than 3,000 children who were sexually abused, and we know the prevalence of sexual abuse in this country. Many of these sexually abused cases, Madam Speaker, is never reported. Therefore, it is not a true number of what we see now. It is my belief that there are so many unreported cases that goes unnoticed in our country. Madam Speaker, also, we have a society of approximately 47% of our children who live in a single-parent home with just mothers alone. And, you know, this statistic tells us that we face a crisis, and I speak about this all the time, a crisis of fatherlessness. Studies have shown that children growing up with absent fathers can suffer lasting damage and also predictive of juvenile delinquency. And these are some of the factors that we see why some of these children possibly end up in uncontrollable, as is stated. We see this playing out in our society, and we must ask the question. We can therefore assume that a number of our people are facing, and as the member said across the aisle, facing trauma daily. And many times this trauma is untreated. Do we wonder why we have so many persons in society so angry? You know, Madam Speaker, when you look at our suicide rate, just the other day I read an article from Dennis Brooks, who's a JCF communication strategist. And he mentioned that from 2020 to 2023, in January, it shows that a total of 173 cases were recorded for suicide in Jamaica. And so we must ask, many of our people are faced with not just trauma now, but generational trauma, and have they accessed psychological care? I would say no. And so, Madam Speaker, when we lock away our children for non-violent crimes because they're not capable of handling their trauma, they're not capable of handling the crisis that they face, and we continue this cycle by not treating them with the proper therapy and the proper care. And so, this therapeutic center will provide the proper psychological and psychosocial care for the children in need. We must understand that they are deemed uncontrollable because the adults are also not equipped to handle the children and the feelings that they're faced with. The parents are not equipped to help them, so they pass them on to the courts, and in turn, they're placed in these correctional institutions with persons who have committed more serious crimes and violent crimes, which in turn, the cycle of this trauma continues. So, Madam Speaker, I stand today in support for the repeal of Section 24 of the Child Care and Protection Act. This will see our children who are displaying behavioral problems placed in the right atmosphere and also get the psychological and psychosocial treatment that is needed. I thank you.
Madam Speaker, I want to thank my colleagues.
Member, there's a discussion taking place in relation.
Madam Speaker, my observation is that I believe both sides want the best for our children. And if we just listen to each other, I think we'll understand that ultimately we want the same thing. There are certain behavioral problems that our children have that meet a certain threshold to go into a children's court. But then there are other things that really are not appropriate, and I believe that we should just pause for a week. Let us just examine it carefully. I gather the minister, oh, very well.
Madam Speaker, I want to thank my colleagues for their support of the bill. It shows where their heart is in terms of the care and protection of our children. Madam Speaker, the Child Care and Protection Act is an act that Jamaicans have called on us to amend. This act went through a significant joint select committee where, as you know, many persons, organizations come before such a committee with whatever concerns and issues that they have. That was in 2016. Madam Speaker, 7 years ago. Do you know how many children have been hurt since then, over the past 7 years? Here we are now. We're trying to change the environment that exists, where children are no longer branded as being uncontrollable. We want the psyche of Jamaicans to begin to see our children who are exhibiting behavioral issues, could be mild to chronic, to see them as children in need of care and protection. Madam Speaker, this should not be a controversial bill. This is a bill that both sides should support. This bill was laid in Parliament last week, a week ago. These are not significant or massive amendments that it's going to take more time, way more time, to consider. They haven't even said what it is that they'll be considering about the bill. But at the same time, Madam Speaker, in the interest of ensuring that we have a unified position on our children, I will wait the week for whatever it is that they will be coming with. But again, Madam Speaker, this is just an example of how things get delayed in Parliament, get delayed as part of the process. It was tabled, adequate time for the other side to take a look at it, but here they go again, wanting a delay. Thank you, Madam Speaker.
You know, members, I just want to say this evening, I want to say, members, hold on a minute, members, I just want to say this evening, members, I just want to say this evening, I want to thank the Minister for agreeing, because I think there is no doubt that all the members of this House are interested, not received it, are interested in seeing the best for our children. And just a minute, my own opinion is that in the interests of the children, and particularly at this time where we have just a week ago spoken about the situation that relates to children, what has happened, notwithstanding that it has been on the table, I think it is only in the best interest of the children that if an additional period is sought for us to lend everybody's views to the thing, because I do not think that there is one member of this House who would not want to see us move forward. And I want to thank you very much, Minister, for acceding, and I feel very sure that the week that we have allotted to the opinions of others will in fact inure to the benefit of our children. And so the question before the House is that the debate is suspended. Those in favor? Those in favor? The debate is suspended. Just a week. Finance.
Madam Speaker, I stand here today to open the debate in this Honourable House of the regulations entitled the Public Procurement, Registration and Classification of Suppliers Amendment Regulations 2023. These regulations, Madam Speaker, seek to amend Part 1 of the second schedule of the Public Procurement, Registration and Classification of Suppliers, Regulation 2019, which I will refer to as the principal regulations, to increase the registration fees commensurate with the maximum registration period of 3 years in accordance with Regulation 9 of the principal regulations. Madam Speaker, this Honourable House would be aware, in 2019, a comprehensive law for public procurement came into effect, and it consolidated and modernized the legislative framework for public procurement in Jamaica. The Act established a Public Procurement Commission, and I refer to it as the Commission, pursuant to Section 9 of the Public Procurement Act to, among other things, promote fairness, transparency and equity in the registration of persons, firms and entities under the Act and the award of procurement contracts. Madam Speaker, Section 11 of the Act grants the Commission the power to, inter alia, approve or endorse the award of procurement contracts above the value of the Tier 1 limit, to register and classify suppliers, approve unregistered suppliers, and assess suppliers on an ongoing basis to ensure the consistency of performance with the registration and classification requirements. Madam Speaker, the registration process undertaken by the Commission serves in part to ensure that suppliers are eligible to participate in public procurement in Jamaica only if such suppliers meet the minimum requirements of technical, financial and legal capability that are prescribed in each category of registration. Accordingly, the due diligence associated with the registration of suppliers includes examination of the applicant's business and assets, product, services, prior projects, as well as a review of financial information. Regulation 10(1) and 2 of the principal regulations provide that upon notification by the Commissioner that the supplier's application has been successful, a fee is payable in respect of the grade in which the supplier has been classified as specified in the first column of Part 1 of the second schedule of the principal regulations. Madam Speaker, these fees are applicable only to those suppliers registering in the works supplier grades. It is to be noted, Madam Speaker, that it was the policy of the Commission in relation to the registration process that once an application was approved by it, a certificate of registration is issued valid for a period of 1.5 years or 18 months. And after the expiration of the certificate, the supplier may elect to return to the register by resubmitting a new application for registration. Madam Speaker, it is felt that the granting of a certificate of registration for only 18 months or 1.5 years is inefficient and costly. In order to improve efficiency in the process of registration and re-registration of suppliers, it was determined that it would be more cost-effective to increase the registration period to 3 years, to double it, in keeping with Regulations 9 of the Principal Act, which states that the registration of a supplier shall be valid for such period not exceeding 3 years, as the Commission may specify in the certificate of registration. So, the Commission has the discretion to register for a period of 3 years, but in practice has only been doing 18 months, and that is now changing. Madam Speaker, this increased registration period is expected to result in an overall reduction in the administrative burden on suppliers who participate in public procurement. It is also expected to positively affect competition by making a larger pool of eligible suppliers for a longer period of time who would be capable of participating in procurement proceedings. Additionally, Madam Speaker, the longer period of registration may attract suppliers or economic operators to Jamaica who traditionally would have opted not to participate in government procurement. You're going to go through all the process of registration, and at the end of the day, in 18 months, you have to do it again. If you're overseas, more of a barrier to participate. So, Madam Speaker, the government, in extending the registration period from 1.5 years to 3 years, is a good thing. It is so let me hear you, it's a good thing. Yes. But the only challenge is that there will be loss of revenue to the Commission, because the Commission is only paid when the registration happens. So if you move from a cycle of 18 months to a cycle of 3 years, then the Commission's income would halve. Make sense? Yes. So we don't propose any nominal increase in the fees. And in fact, since 2003, there's been no increase in the nominal level of the fees. 20 years. Maybe we should really look at it. But what we need to do is ensure that the Commission is not out of pocket. Okay? So if for 18 months the registration fee was $50,000, then for 3 years for the Commission to be not out of pocket, the registration fee would have to be $100,000. And that is what this that we are tabling here today and debating here today is designed to do. To support the Commission in lengthening the registration period from 18 months to 3 years, but to do so in a way that is revenue neutral. So, Madam Speaker, the regulation is being made pursuant to the powers granted under Section 61 of the Act, which provides that the Commission may, with approval of the Minister, make regulations prescribing, among other things, the forms, the fees, the content, and are subject to affirmative resolution. The Public Procurement Commission has submitted these amended regulations to me, Madam Speaker, and I have approved them and have brought them to this House for affirmative resolution. Madam Speaker, the Public Procurement Registration and Classification of Suppliers Amendment Regulations 2023 will therefore enable the Public Procurement Commission to efficiently fulfill its functions of registering and re-registering suppliers. Now let's look at each clause of the very simple regulation. Clause 1 of the regulation, Madam Speaker, addresses the preliminary issues of the regulations. It sets out the title, which is cited as the Public Procurement, Registration and Classification of Suppliers Amendment Regulations 2023, and must be read and construed as one with the principal regulations. Clause 2 of the regulations amends Part 1 of the second schedule by increasing or by adjusting the registration fees for each supplier grades. Grade 1 and 2 will move from $60,000 to $120,000. Grade 3 will move from $30,000 to $60,000. Grade 4 from $5,000 to $10,000, and grade 5 from $1,000 to $2,000. These do not represent increases because the registration period is being doubled at the same time. You used to be registered for 18 months, and now you're going to be registered for 3 years. Madam Speaker, I don't know what took you so long. Madam Speaker, with this amendment, this amended regulation, the government intends to fulfill its commitment to maximize economic output and economic efficiency in public procurement, to promote economic development through public procurement, and to obtain value through public procurement, to foster transparency, and to encourage participation in public procurement. Madam Speaker, I now invite members of this honourable House to support the affirmation of these amendment regulations. Thank you.
Madam Speaker, I've listened intently to the Minister, and the Minister has said a lot with little, because I agree, and I think this side agrees, that the amendments that are being proposed are revenue neutral and are likely to achieve the aims and objectives the Minister has outlined. What I would ask the Minister, though, I think, and someone on that side said the measures were transformational, I would suggest to the Minister that it is like it would have been far more transformational, and I was really hoping that the Minister would come today with a resolution of this nature to speak to and address two critical issues that would have been truly transformational, and that is the set-aside arrangement under the Act, under the procurement amendments, and the special and differential treatment measures. Now, Minister, those are two transformational elements in the Act itself. And when the Act was amended, we both agreed, both sides in the debate, agreed that the set-aside and the special and differential treatment were two elements of the Act, two components that would have been truly transformational because they would impact in a very significant way the micro, small and medium-sized enterprises sector. And Minister, what in the opposition in supporting the regulation would want to find out and want to know from you the far more transformational impact of the measure that would flow from both the set-aside and the special and differential treatment. Well, this isn't a transformational element that was promised. What I'm asking is truly transformational, which is the set-aside and the special and differential treatment. Where are we on those particular measures, which are directly related to the Procurement Act and what would really have given this the kind of impetus that we need and the transformation that is truly needed?
Madam Speaker, I'm not too certain that the member understands. You want to respond to him?
Madam Speaker, the member's description of set-aside is on the record, and he used the word transformational. And I want to be as gentle as possible with the member because he is my friend. Madam Speaker, earlier you spoke about paying attention in the Parliament to the laws that are being passed. Madam Speaker, the measures of which the member makes reference were duly passed in this House in November of 2019 and are indeed transformational, and those measures are in effect and members are benefiting from them. The set-aside regulations and the other one that he mentioned. So, So just to be very gentle with the member, Madam Speaker, today is 2023. He describes it as transformational, and transformational indeed it was. And I thank him for that endorsement of laws that have been passed in this House by this government 4 years ago in November 2019. Now, if the member has anything to say on the regulations before the House today, I'd be open to hearing it. But if not, I'd invite him to join me in the affirmative resolution to the amendment regulations on the floor of the House today.
Madam Speaker, what we both agree on, and the point I made, I think the member did not hear me properly. No, just clarification. No, it's a clarifying point. No, I didn't say it wasn't passed. It was passed. We acknowledge that. We acknowledge that. What we're talking about was the operationalization of the provision. It's the operationalization of the provision that I was speaking to and asking the minister if he could say how those provisions were being operationalized. This is an amendment to the regulation about operationalization of the fees related to those amendments. Because the micro, small, and medium-sized enterprise sector have been complaining about those particular provisions. That's why I raised it.
Madam Speaker, the member is sort of digging a hole, but he's my friend. With the greatest of respect, right? The set-aside regulations were passed in this House, not November, it was September of 2019, and they're operational. The NHT, for example, I can speak about NHT with authority, that NHT is in the process of, has done it this year, last year, the year before, awarding contracts under the set-aside regulations to MSMEs. They are operational and in play. And today, in 2023, we have on the table something entirely different. And it has to do with facilitating ease of registration or greater ease and efficiency with our suppliers by allowing for a longer period of validity of the regulations. But to do that in a revenue-neutral way means that we have to come to the House and make an adjustment to the fee that is paid to be commensurate with the time, the lengthening of the time period of registration. Madam Speaker, I invite members of the House to support, by way of affirmative resolution, the amendment regulations here. Oh, you want to speak? Oh, no, go ahead.
Madam Speaker, I want to commend the Minister and the government for having brought this here today. I've been fighting since 2007 for this change to be done at the Infrastructure Committee of Cabinet. We went very far with it. It fell off. We came back after 2016. It's been a long road. It took a long time. But finally, contractors don't have to go through this laborious process of every 18 months have to ask for re-registration again with the same issue. They have breathing rooms now to re-register through the years. And I thank you, Minister. It took a long time, you know, and I commend you for having taken it here eventually. And Madam Speaker, I'm happy that it's here, and it means that my labor has grown fruit from 2007 till now. There are two others been fighting for, and then very shortly, the Honourable Minister, the very capable Minister, will be taking them also. So, Minister, on behalf of the contractors of Jamaica, I wish to thank you and the full Parliament for having brought this here for affirmative action today.
Madam Speaker, the member indeed has been a very consistent advocate of this reform, and I thank him for his advocacy and for his kind words just now. May I ask, Madam Speaker, that the House approves the amendments, that approves the motion.
Before the House is that we approve the motion. Those in favour? Aye. Those against? The ayes have it. Minister, the motion is approved.
Madam Speaker, it is not intended to do any further business for today. I therefore move that the House be adjourned until Tuesday, Tuesday, July 11th. And that was for the benefit of the leader of opposition business. Until Tuesday, July 11th at 2 p.m. at the George William Gordon House. May it please you, Madam Speaker.
The question before the House is that we do adjourn until Tuesday, the 11th of July at 2 p.m. Those in favour? Those against? The ayes have it. This House is now adjourned.